From the National Constitution Center in Philadelphia, this is We the People. I'm Julie Silverbrook, Chief Content and Learning Officer. The National Constitution Center is a nonpartisan nonprofit chartered by Congress to increase awareness and understanding of the Constitution among the American people. As the nation marks its 250th anniversary, we're taking a close look at key events in the decades around 1776. From the drafting of the Declaration of Independence to the ratification of the Constitution in 1788. To understand how America's constitutional democracy took shape in this period, we're looking closer to the ground in the states. In this period, Americans were not only declaring independence, they were giving it meaning. By writing state constitutions, by experimenting with new forms of self-government, and by grounding political authority in the people. These early state constitutions were the first to define the American constitutional tradition. To explore this critical and often overlooked chapter of the founding era, we're joined today by Robert Williams and Nicholas Cole. Robert Williams is a distinguished professor of law emeritus at Rutgers University School of Law. He is a leading expert in state constitutional law and directed the Center for State Constitutional Studies at Rutgers. Professor Williams has authored extensive legal scholarship on state constitutional law, including the law of American state constitutions and state constitutional law cases and materials. Robert, welcome to We the People.
Thanks very much, Julie. It's great to be here.
And Nicholas Cole is a senior research fellow of Pembroke College at the University of Oxford in the UK and director of the Quill Project, which provides cutting-edge tools to help teachers, lawyers, and researchers interpret and teach key historical texts. His work highlights the political thought of the 18th and early 19th century. Nicholas, welcome to We the People.
It's a pleasure to be here.
Wonderful. Bob, I want to start with you. How did the May 15th, 1776 resolution emerging from Virginia, including its preamble, help move the colonies from resistance toward independence and the creation of new state governments grounded in the authority of the people?
You have to remember that the idea of independence was really not unanimous at that time, but it was, of course, on everybody's mind. So on May 10th, the resolution directed states to begin to form their own governments. The drafters decided not to suggest a particular model. They left it to individual states to decide what they wanted to do. But they didn't issue it immediately. They formed a committee to write a preamble. And the preamble was drafted and released on the 15th of May. And that was the justification for forming colonial governments that would have complete self-government. And it actually read like a Declaration of Independence. So this was the first national official statement about both independence and the formation of colonial self-government. It also resulted in these people being viewed as traitors in England. It took their lives in their own hands, but it linked independence from England and colonial self-rule directly together.
And it's significant, right? Because it precedes July, right? It precedes the passing of the resolution declaring independence and the signing of the Declaration. And so it's significant that even before independence is formally declared across the colonies, these colonies turned states are actually already in the process of setting up their own individual systems of government. Nicholas, do you want to talk a little bit more about that?
Well, I guess, one question is why was it happening then, and why did it take so long? Remember, the king has already issued a proclamation the previous autumn, the previous fall, to say that those who are opposing the British are committing treason. There is beginning to be a bit of a power vacuum in different places in America, and so just good order and people's ordinary lives are beginning to be affected by the growing conflict with Britain. And then there's a collective action problem. So John Adams wrote at the time, and again very much later, that independence required 13 clocks to strike at once, which is a famous and wonderful metaphor. Younger listeners have probably never tried to get two clocks to strike at the same time, but the metaphor is about something that's almost impossible. And people realize that if independence is going to be achieved, it's going to need at least the 13 colonies to act together. And so there's this interesting interplay where people in Congress, again, not universally, are trying to nudge the states to respond to the fact that really the British government has said, well, you're already in a state of rebellion. But on the other hand, Congress can only act with the consent of the states. And I think you see a sort of microcosm of later arguments about federalism just in that moment. So you have on the one hand nudges from Congress, but you also have these very important resolutions in localities and in the states, and the Virginia resolution also nudging towards independence. And I think the surprising thing in a way was partly that it took so long, but also that in that moment it was possible to align everybody across 13 colonies and to act collectively. So I think the Virginia resolution is part of this process of getting everybody to that point. And it's easy to dramatize this as a debate that happens just in Philadelphia. But of course, that's not really the case. It's a debate that has to happen without the internet across a huge geographic territory. And as Bob says, it's really important to remember over and over again, these are collectively authored documents. They're being drafted by committees, people are involved. This isn't, one person's take on what independence should be. These are quite considered pieces. So a resolution coming from Virginia in that spring is quite a powerful moment. And there are similar things happening in other states, in South Carolina and all over the continent. People are thinking, well, we've got to respond to both British actions, but also the potential collapse of government and good order locally. And that's what's happening, I think, in that spring.
So let's talk about what state constitution making looks like in that period before July of 1776. Bob, can you tell us a little bit more about what that looked like?
Yes, it's interesting that New Hampshire, for example, in January of 1776, developed quite a rudimentary temporary state constitution, which also served almost as their Declaration of Independence. And in also June, Virginia came out with its constitution, and on July 2nd, our state of New Jersey developed its fairly rudimentary state constitution. One of the delegates wrote home from a tavern, "We shall have a republic established within a week." So it was all very hasty there. And these drafts were developed by the revolutionary assemblies, not by separately elected constitutional conventions. So these were the bodies that were also involved in ordinary legislation at the time. But the drafters already had some experience with local self-government under the colonial administration. But states like Connecticut and Rhode Island did not do state constitutions right away. They rather just relied on their charters, simply changing a few words from colony to state and things like that. But uniformly, they rejected the British model, and they rejected the colonial administration model, and wrote constitutions that relied on what we call little r republican government, popular sovereignty. And republicanism, interestingly, was a bad word in England, and it was also a bad word among the loyalists in the colonies. But it was the expression of popular sovereignty. And all of these drafters believed in republicanism, but they had a wide range of disagreement about the details of that.
Nicholas, I want to talk about the shift after independence, which clearly changes the stakes across what was colonial British North America. And after the Declaration of Independence, there are these independent states. So the process starts to really accelerate quickly. So you have a handful of states that do some constitution writing or modify their colonial charters before July of 1776. In the months and years that follow, there's a lot of constitution writing that unfolds. Can you talk a little bit about that process post July 1776 and why there was such urgency to set up new forms of government in the states?
Well, the Articles of Confederation government doesn't claim to be able to pass legislation that touches individual lives. So there's a real problem if you're declaring independence. There isn't what we would think of now as a sort of national government that is able to make law and enable the ordinary business of life to go on, because even in wartime you do need to have government. People do need to be able to settle disputes. There do need to be resources raised to prosecute a war, and so it is essential that you know who is in control and what the basis of their authority is. And one of the interesting things about the American case is that all of the colonies are used to being governed by some kind of charter or instrument of government that says where rightful authority lies. So it would have been very odd if they had just somehow drifted into a revolution that is very much built on the principle that the British are trampling on the rights of government that they think they possess. It would be very odd for them to then sort of carry on without some kind of instrument that says these are the people who are legitimately in charge of the state. It was also an opportunity for the case for independence to be made on behalf of the individual states, and most of these early constitutions contain some account of the fight with Britain and why British government is illegitimate. So there's a real urgency to have some kind of government that can function and can prosecute a war, but can also enable people's lives to carry on. And because of the American context, it's probably got to be a written document. So then the question is, well, who gets to write that text? And if your complaint is that a British monarch has been making proclamations that he shouldn't have made and been interfering in colonial government in a way that sort of highlights the nonsense of royal authority, which is, Tom Paine's case in Common Sense. And if your claim is that Parliament has overstepped its boundaries, it's then very natural that you would write texts collectively in some kind of process that would lay out the community's sense of what government should be. So whether it is the state legislature or, as becomes increasingly common, some separate body of people, there are lots of reasons why America should very rapidly settle on the idea of a written constitution, not written by a single lawgiver, and preferably, if circumstances allow, a written text that is ratified by the people as well in some kind of process. And so you see those elements taking shape remarkably quickly, in a way that, does become very influential globally, but hasn't been always the way revolutions have proceeded. And this American case is really a very striking instance of this unfolding in what looks like a very orderly and very thoughtful kind of way, very, very quickly from 1776 onwards.
But it's sort of interesting, right? Because I think if you look back at this period of state constitution making, you could say, oh, what an orderly process. But they're actually doing this in the midst of war, and in some instances, the legislative body that's actually doing the drafting actually is on the move, right, to evade capture. So it's actually a really extraordinary moment in world history that so much thoughtful constitution writing is happening in the middle of active hostilities with the world's most powerful military at the time.
Yeah, no, it's absolutely. I mean, Congress itself has to move because of British troops, and it's not until 1777 that they in January they were able to print a second version of the Declaration of Independence that says, this is the unanimous declaration of the colonies, because at the time when they'd done the first printing in July, they hadn't been able to put the word unanimous into the printing because New York hadn't yet been able to formally agree. So, and the second printing is not in the same place because they are on the move, and it's the same for the state governments. Some of them really are threatened by British military movements and are having to relocate. But amid all of that, there is a real effort to say, we are going to do this in an orderly and proper way. And you even see in some of the early constitutions where there is perhaps some sense that hasn't been possible. Both of South Carolina's early constitutions explicitly say that they are provisional, because circumstances don't allow for the full working out of government that perhaps people would have wanted. So yes, I think it is remarkable for its orderliness, as you say, with occupying forces at the gates.
Bob, I want to drill down on the details a little bit about looking at the process that actually happened on the ground. Who was involved? How were these documents debated and approved, even in the context we were just talking about?
Well, it was very experimental. We now talk about the laboratories of federalism, and this was the early example of that. It's been referred to as the most intense constitution-making period in history, and I think that's accurate description of the years from 1776 to 1787. And there were a number of elements to this. The first one was really, as Nicholas mentioned, what process should be used to develop these revolutionary state constitutions, or colonial constitutions as they were thought of at the time. And by process, I mean, who should draft these constitutions? Should it be the ordinary revolutionary assembly, or should there be a separately elected constitutional convention with only one task, and that is to draft a constitution? And we saw the development of the idea of a form of higher law, something more permanent, more fundamental than ordinary legislation. But also, who should be able to participate in those deliberations? Finally, should the convention have to put its product out to be ratified by the people? So these were all procedural elements of constitution making that then led to questions about the substance. Well, what should be in these early state constitutions? Should they have two houses? Should they have an upper house to slow down the proposals of a lower house? Should there be a separately elected governor who might have veto power, but who wouldn't have the sort of prerogative lawmaking that we see in the British governmental system? Should there be a Declaration of Rights? What should be the powers of a state legislature? All of these questions also bedeviled these early drafters. And as a result, there were sort of two waves that developed in these early years. The first wave was represented by the radically egalitarian Pennsylvania state constitution, that was adopted in September of 1776, which has been referred to as the outer limit of the revolution. This was a radical people's government, a unicameral legislature, no upper house, no elite Senate to stop what the legislature was enacting, no governor, no veto power, an executive committee to implement what the legislature did, and a dependent set of judges who owed their seats on the courts to politicians. Yes, there was a Declaration of Rights, but this Constitution had the rhetoric of separation of powers, but it didn't have the teeth of checks and balances the way we recognize them today. This kind of a model had to wait till 1780 when it was developed in Massachusetts. There was an early 1778 Constitution proposed and voted down by the town meetings. But the 1780 version is a model that's recognized by most of us now in the United States. It had a two-house legislature with a more elite upper house Senate, an elected governor with veto power, independent courts that could enforce the Declaration of Rights and the separation of powers principles. So we saw the development there, and in 1784 in New Hampshire, similarly, the rhetoric of separation of powers backed up by the teeth of real checks and balances.
This is such an extraordinary period because it's truly experimental. There is information being exchanged amongst the states, so they're actively learning from each other as they go into constitution making, and then actually the systems of government go into operation under these state constitutions. What explains the variation that we're seeing at this time period, Nicholas?
Well, I think one thing we can look to is, as Bob says, the extent to which processes are dominated by more or less radical Republicans, because there's, in a sense, two conversations going on. One is, should the colonies be self-governing states independent from Britain? And the other is, should the nature of government fundamentally change? And there's perhaps more appetite in some places rather than others to see more radical developments. But I think the other thing we have to say is what extraordinary continuity there is with some colonial institutions. So that, we can talk about lower and upper houses, but we could talk about pre-revolutionary legislatures and governors' councils. And in many places, the state constitution looks like a refinement and a more idealized form of institutions that people already have experience of. So because things are different in different parts of America, even before the revolution, before the Declaration of Independence, I don't think we should be surprised that there is some variation afterwards. And of course, unlike revolutions that have begun with a unitary authority at the top, telling localities how to arrange their government, the American state has just never functioned like that. The states have been sovereign from the beginning and wrote their constitutions, most of them, without even mentioning a union at all, even though they were part of a union from the beginning. But they write their constitutions, even insofar as they're declaring independence, with tentative reference to the fact that there are other colonies, perhaps. But really, these documents read very much as if they are fitted for the state itself. So I think all of those factors give us variation in the documents that are being produced, and I think we shouldn't be surprised that there is variation, because there wasn't a force pushing them towards a single solution. But I think it is also true that this is a period of great experimentation, and the different states do look to each other, and do ultimately look to the federal institutions as well, and begin to coalesce around particular ideas that become norms. And so the range of variation over time remains much broader than you would find in almost any other multi-level system of government. But the range of variation probably declines as people say, no, that's a good idea from over here, and that's a bad idea over here. That hasn't worked. You know, the Council of Censors experiment in one state just fails and is not copied by others. You know, they think of it as a bad idea, for example.
I want to talk more about constitutional design, but before that, I want to take just a quick step back to talk about the ways in which these constitutions are redefining where political authority comes from. And we've touched on this just slightly in talking about the bodies that were creating them, but want to go into more about the intentionality in the making and design and how that relates to where political authority comes from.
Remember the touchstone of this was republicanism and self-rule. And the one point about Nicholas's point was that the colonies had different experience with colonial administration. So remember, Connecticut and Rhode Island were satisfied to simply rely on their charters with a couple of amendments, whereas if you look at Pennsylvania, there was real opposition to the colonial administration. Voting, even the limited self-government, had to do with very limited voting opportunities. And in the new revolutionary regime, voting was expanded broadly, and just almost the whole colonial administrative model was rejected. So it was all over the place there. But again, the touchstone was self-government. And the experience with the charters was translated pretty quickly into the concept of a higher law that would control the mechanisms of ordinary government. And you have to remember this, both independence itself and the idea of complete self-government was incredibly heady and exciting. That Tom Paine, in his famous pamphlet, Common Sense, said, just listen to this. We have every opportunity and every encouragement for us to form the noblest, purest constitution on the face of the earth. We have it in our power to begin the world over again. A situation similar to the present hath not happened since the days of Noah until now. The birthday of a new world is at hand. So this is the kind of feeling that these drafters had, many of whom were also involved with the arguments for independence. And it led to a pretty egalitarian set of documents that are the basis for our state constitutions today.
I think it's also worth not overlooking the radical statements in many of the early bills of rights about the proper origin of government. So, going back to the Virginia's Bill of Rights, for example, or the Bills of Rights in other states, they make important claims not only about which rights should be protected, but what the origin of legitimate authority is, and make clear statements that legitimate authority flows from the people. And of course, the contrast is with governments of accident and force, as Hamilton would describe them in the Federalist, or with claims albeit soft claims in the British case, but claims nonetheless of some kind of divine authority to rule. And the American states make clear statements as they lay out the legitimacy of their own governments that legitimate authority flows from the consent of the people. That the cause of rebellion might be listed as a series of awful things that the British did, and the states disagree to an extent about exactly which ones to emphasize. But the common thread that they all start to emphasize, where they say anything at all, is that legitimate authority flows from the people. And that's a really important dividing line. And this idea that, the world is beginning anew is, of course, captured on the seal that they will eventually adopt for the federal government, which is on everybody's dollar bills. If you look on the, I think it's the left-hand side, isn't it? The pyramid shape. Well, there's Latin round it that recalls the founding of Rome and the beginning of a new order. So I think that idea that this is a moment when things can be put right, and this is a clean slate that doesn't come along very often, that really is infused through so many of these texts.
It's both a statement of political philosophy, but also reflects the reality that government is no longer derived from their charter and the king, and is now derived from the people collectively in the states who are creating a new form of government. So there's both a philosophical and practical reason for naming that in the state constitutions. I do now want to talk a little bit about constitutional design. So how they structure government, especially the legislative and executive branches, to guard against tyranny. Because while these are really thoughtful, considered documents, they're also, I want to say they're sort of like trauma documents in a way, right? Like they're coming from this trauma period of over intervention in their government, and they're very concerned about power and how power is divided, and they're concerned with preventing tyranny. And so let's start with Nicholas on this one. Do you want to talk a little bit about legislative and executive design that is really responsive to the realities of what's happening in the lead up to the revolution in response to the king and parliament?
Yes, these are documents that are deeply concerned with the possibility of tyranny. I think one of the interesting things, though, is that, as I think both of you mentioned earlier, the idea of separation of powers as we would now understand it doesn't really shine through to quite the degree that one might have expected. People knew that there were three branches of government, and the constitutions reflect that in a way, but perhaps without the clarity of later texts. Governors are frequently denied powers that we would now think of as quite normal. So they're frequently denied veto and pardon powers. Indeed, pardon powers, if they exist at all, are sometimes moved to the legislative body itself. So the legislatures in these early constitutions typically emerge as quite powerful bodies compared to the judicial and executive branches. But I think the reason that many of the designers of these constitutions thought that that was probably all right was that, first of all, they thought elections would be very frequent. And so the opportunities for the legislature to really get out of sync with the will of the people were more limited. And secondly, the rhetoric of the revolution very much contrasted the virtue and good sense of the American people with the misbehavior of the king's ministers and appointees and people in government. So there is a suspicion of government officials and to an extent then executive officers, even if they're being appointed by the state, that carries through into some of these early constitutional designs. And one of the things that they are very, very suspicious of are what are known as prerogatives. Those are the things that the king had been able to do merely by dint of being king, not by virtue of enacting a law. And so these would very much be things like vetoing legislation, signing treaties, pardoning people. And so these constitutions tend to strip back things that are associated with royal prerogative or prerogatives that governors had exercised on behalf of the king, and tended to focus a little bit more than we might have expected on the supremacy of a legislative body, be that in one house or two. And again, that's something that over time American states are going to adjust.
Bob, do you want to talk a little bit about how much authority is given to the legislative branches, in particular, in the state constitutions?
Nicholas is quite right. For these early state constitution drafters, legislatures were the heroes and governors were the villains. The legislatures appeared to be the embodiment of popular sovereignty, of Republican, little r, Republican government. And governors were not permitted to use the prerogative power. In other words, not to propose rules by decree, and not to have, most of them didn't have veto power in these early constitutions because of the dissatisfaction with the colonial experience with royal governors. Legislatures were, by contrast, given almost all power. And in these early constitutions, the judiciary was sort of forgotten. It is true that in Massachusetts' 1780 Constitution, there was a clear enactment of independent judges, but there wasn't a lot of thought given to litigation and court procedures back then. So the legislatures were the winners, the executive branch was the loser, and courts were sort of forgotten. But the judiciary began in these early days to develop the idea of judicial review, so that, and by judicial review, I mean the ability to declare actions of the executive or laws passed by the legislature to be unconstitutional. And we have several very early examples in the states of this. New Jersey is thought to be the earliest. In 1780, while the war is still going on, the New Jersey courts declared a law that gave people accused of trading with the enemy only a 6-person jury trial, while the Constitution provided a jury of 12. And the judges enforced that. Amazing, even during wartime, for somebody accused of trading with the enemy. And fairly quickly, there were a number of states, including Virginia, where the courts engaged in judicial review long before what we all learned, the Supreme Court case of Marbury versus Madison in 1802.
Now, they're not only concerned with structures, there's also a strong emphasis on rights, which are central to the state constitutional story as well. Bob, what kinds of rights did these early state constitutions protect, and how were they understood at the time?
It's a very good question. The question of what rights should be protected in state constitutions was very important, but the specific rights were basically the rights of Englishmen, the well-established rights that even colonists claimed, and was the right. These various rights arguments were part of the rhetoric of revolution. The difference here was that they were going to be written down, and some of the earliest state constitutions didn't have declarations of rights. But when you looked at that Constitution itself, often they included certain rights. New Jersey is an example of that. Even without a Declaration of Rights, the jury trial right was in the Constitution itself, and that's what the New Jersey courts enforced in that 1780 decision I mentioned. But these rights sort of became a standard catalog for states that would include a Declaration of Rights. And the idea of a Declaration of Rights became pretty standard. And of course, it was part of the arguments over the United States Constitution. A couple of things, though, some of these rights in the early state constitution were described as rights that should be recognized. And some people thought, well, this maybe meant they weren't really enforceable. The general thought at the time was that they bound the state legislature and the state executive, and that they were sort of communitarian rights, not so much individual rights. But quite soon the idea developed, as in the New Jersey case, they would apply to individuals. And what's interesting is many of these early state constitutional rights, free speech, freedom of religion, freedom from illegal search and seizure, they're in the state constitutions today, and they're still very important in state court litigation. For example, in Pennsylvania, the 1776 Constitution said elections must be free and equal. That was the basis for the most recent cases on striking down the requirement for voter ID and striking down political gerrymandering. So the enunciation of rights back at the beginning is still extremely important in our American constitutionalism.
I think in some of these early documents, you see a sort of mixture of aims. So if you think about the 1776 Virginia Bill of Rights, so some of the early statements are really statements of principle, statements that the people have a right to a government that they can rebel against if it becomes tyrannical, for example. It's very hard to see how you would go to court and litigate that. And a statement that all power is vested in and derived from the people. I mean, that's a statement of philosophical principle. And then as you work down the Bill of Rights, there start to be things that you could imagine going and arguing in court or before the legislature. So there should be no hereditary offices, for example, is a statement in the Bill of Rights, and through down to rights about the militia and other things that we would recognize from more recent bills of rights at state and federal level, and things that you could imagine more easily enforcing. And as Bob says, it's absolutely true as well that things that we think of as critical rights are sometimes in the text of the main constitution as opposed to separated out into the Bill of Rights. So I think these early statements of rights are doing a very complex set of jobs. They're both stating rights that you should rely on, but they're also stating some broader philosophical principles as well that I suspect wouldn't be drafted into a modern Bill of Rights if we were going to rework a Bill of Rights, because we now think of bills of rights as principally things that you can go to court to enforce. I think there's a slightly broader sense in these early declarations that there are a number of things that a Bill of Rights has to achieve, and some of these are slightly more philosophical than they are enforceable. I think the other thing to point out as well is that they often read as catalogues of accusations against the British. So the rights that people protect most deliberately are the rights that the British have trampled on. So a particular concern in the run-up to the revolution is the idea of general warrants, because the British had wanted to issue warrants that essentially allowed people's property to be searched without any sort of real suspicion of wrongdoing. And so that's something that finds its way into many bills of rights. And if you if you read across between some of the accusations in, say, the Declaration of Independence and some of the early Bills of Rights, then many of the misdeeds that the British government and George III are accused of find an expression in a kind of positive statement of rights in the Bills of Rights, which also means they're not sometimes as comprehensive as we might have thought that they would be. That they aren't a complete statement of all of the rights that might be trampled on, but often seem to be most prominently a statement of those rights that the British have infringed most deliberately.
I want to shift from talking about the design of the constitutions to talking about how they're operating in practice at the time. Nicholas, how are they operating in practice, and what challenges or tensions emerged during this period?
I'm going to come back to my theme of orderliness because one of the interesting things about the governments is the way in which they are, for the most part, able to establish that they are the legitimate authority in the state. There isn't a great spat between different people in the state claiming to be the people really speaking for the revolution, or other people wanting to establish competing governments. I mean, it is remarkable how this process of writing a text and having elections in wartime for governments and their officers and even judges. It is incredible that this process of selecting people in a republican way is able to establish governments that are able to exercise control, except where the British are really occupying. But at the same time, there are real challenges. So, if Republican theory was suspicious of executive figures, how was that to be squared with the needs of wartime? And Thomas Jefferson, very famously in Virginia, looks at his state constitution and says, the governor can only act when he's authorized to do so by law, and refuses to take measures seizing property, for example, of loyalists or that are needed for wartime measures, because he said, I just don't have the authority to do it. And this worries some people during the revolution, and people say, well, maybe we've gone too far, actually, or maybe we can have our constitution, but we need emergency measures, or maybe we need to revise these constitutions to make governor figures more powerful, or to and sometimes the commander-in-chief of the forces of the state becomes a really important figure. So actually, I think the South Carolina 1778 Constitution is issued in the name of the commander-in-chief, which is a slightly extraordinary sort of moment, but I think captures this idea that there is actually a war on, and there are actually emergencies to deal with. And sometimes that sits a little bit badly with some of the more gentle, more consensual focused elements of Republican theory. So I think the early states are having to navigate this. And of course, if the British hadn't, been an invading force in Virginia, Jefferson wouldn't have been confronted with this problem. So I think, wartime really does show the potential flaws in some of these early experiments, as well as show their great strength and virtue, because of course they do ultimately win, and they do manage to repel invasion.
Bob, a similar question to you, but I want to think about the impact of the successes and challenges under different state constitutions, what that impact was on the delegates to the Federal Constitutional Convention in 1787 as they're designing a new system of national government.
Yes, it's very important. Many people think the federal constitution was just drafted in sort of a vacuum, or by people who were relying on philosophers and the experiences of ancient governments and things like that. But in fact, I mean, those things were true, but one of the main reasons for the Federal Constitutional Convention, there were several, of course, but one of them was what was going on in the states, particularly by these overly authorized state legislatures without effective checks and balances in place. And at least between 1/3 and 1/2 of the men who came to the Federal Constitutional Convention had experience drafting, debating, or serving under these early state constitutions. So, famously, John Dickinson of Delaware stated, "Experience must be our only guide," referring to the experience of the states under their state constitutions. So during the debates in the federal constitution, a lot of references were made to the extremes that some of the state legislatures had gone to and positive and negative examples from the states. Not surprisingly, many of the negative examples referred to Pennsylvania. Almost all of the Pennsylvania delegates had been opponents of the radical Pennsylvania state constitution. So there were a lot of statements like, let's don't do what they did in Pennsylvania. And so we see the Massachusetts model with so-called mixed or balanced government being the favored model. Let's have two houses. Let's have a Senate that's more elite than a House. Let's have a single elected president. Let's have independent courts. So these references went back and forth through the federal constitutional convention. Interestingly, right away in 1790, Pennsylvania had a state constitutional convention and adopted an entirely new constitution that modeled on the federal constitution and the Massachusetts constitution, a complete rejection of the frankly catastrophic experience in Pennsylvania with no checks and balances. And then, interestingly, the state constitutions have evolved over time to the current time, where they often look really quite different from the federal constitution upon examination. Yes, they all have three branches. Yes, they have independent courts and things like that, but they're much more easily amended, and their distribution of powers can be pretty different. They have elected judges and things like that. So the freedom that the states were given at the beginning to develop their own models of constitutionalism have been followed throughout the 250 years of our constitutional democracy, and they will continue to operate independently of the federal constitutional model.
Nicholas, I want to pose a similar question to you, which is what structures get embraced in the federal convention coming from the states, and what structures do they start to move away from? And then Bob started getting at the period after 1788, when the federal constitution is ratified. We start to see another period of state constitution writing, and then those state constitutions are starting to look more like the balanced federal model. So if you don't mind taking on both of those, that would be great.
Sure. I mean, one point to make is, it wasn't remarkable in 1787 to think that there might be a constitutional convention that would proceed in an orderly way, that would consider draft texts, that would amend those texts through a process of formal debate, that would keep records in an orderly way, that would publish its text, that would recommend that this text be ratified by the people in some way, because this was a process that the states had themselves, with variations, but started to settle on. And as Bob said earlier, in Massachusetts, it was very important that the 1780 Constitution was written by a special convention, and it then went through a ratifying process in the state. And people have come to think of that as the proper way to do things. And the structure of the federal government with two houses, with an executive branch, with a judiciary, this again looks familiar from state level and signals that this is a serious constitution with three branches of government. But then there are ways in which it diverges from what people expect, and this becomes really important in the ratification debates. So for many, the fact that the House of Representative elections are only going to be every 2 years looks like a departure from some of the ideals of the revolutionary governments. The fact that the Senate can't be removed all at once looks like a departure. The fact that senators are going to have such long terms of office. The fact that the president is going to have a long term of office. These all strike some of the early readers as quite significant departures away from the experiments in self-government that are going on at the state. So there's a mixture in the federal text of a set of institutions that look familiar, but look to be at one end of a spectrum of, as it were, radical experiments in government and less radical experiments in government. And then the federal text has to do something that state texts do, but they don't do it quite as explicitly. So often within a state, a constitution has to balance the distribution of power between different regions. And you often see the writers of state constitutions worrying about which counties are going to get how many votes, and this kind of question. It's a little bit more obvious at federal level that there is an effort to balance the relative influence in the government between different areas of the union. And again, that provides a lot of fodder for the ratification debates and for people to argue about whether that distribution is correct. And then the last thing that the federal text has to do, which the state texts can be entirely silent on, is to try and find some kind of dividing line between state and federal authority, and to say these things we are claiming for the federal government, and these things we are not. And of course, state texts don't have to do that, but that is one of the really critical things that the federal text has to do. But then, as Bob said, there is influence both ways. So the federal constitution comes to influence constitution writing then at state level, and phrases that are in the federal text find their way back into redrafts of state constitutional texts, and ideas from the federal text find their way back into state texts. So there is this dynamic process of influence that runs both to and from the state and federal governments.
Final question for you both as we come to the close of our time together. Lots of people are reading about early American history as we mark the nation's 250th. If they want to read one book about Revolutionary era state constitution making, what is the book that you would recommend?
Well, I'd recommend for a slightly interesting take, Alison LaCroix's recent book on the interbellum constitution, which is a really lovely work that considers constitutionalism in the round, and both how the politics works and how the law works. And although it runs down to the period of the Civil War, I think it gives a sense of the sort of possibilities of what the revolutionary generation were able to achieve. So for a book that really makes people think again about how the American system of government has always worked, I think that is a great recent book.
Bob, what book would you recommend for people interested in learning more about early state constitutions?
I would recommend Gordon Wood's book, The Creation of the American Republic.
Fabulous. Well, Nicholas, Bob, thank you so much for joining me on today's episode of We the People. It was really delightful to explore the incredible period of constitution making that happens in the revolutionary period. It's understudied, and I hope that you've inspired our listeners to go and learn more. Thank you.
Thank you.
Thank you so much for having us, Julie.
This episode was produced and mixed by Bill Pollack with production support from Charles Somm. Research was provided by Anna Salvatore, Trey Sullivan, and Tristan Worsham. Please recommend We the People to friends, colleagues, or anyone, anywhere who's eager for a weekly dose of constitutional education and debate. We're excited to share that the National Constitution Center will publish a book on May 12th, The Promise of America, Reflections on Our Enduring Ideals, a keepsake volume exploring the ideas at the heart of the American constitutional tradition. The volume will be published by Simon & Schuster. To learn more and pre-order, please visit constitutioncenter.org/Promise of America. And as always, remember that the National Constitution Center is a private, nonpartisan nonprofit, and we rely on your generosity, passion, and engagement for all of our programming, including this podcast. Please consider donating today at constitutioncenter.org/donate. On behalf of the National Constitution Center, I'm Julie Silverbrook.